We're going to call the meeting back to order. We're moving on to agenda item number 8, license appeal hearing. Mr. Jack B. Hunter for possible action. Mr. Hunter is appealing a revocation of his hunting privileges.
My name is Jack Hunter. I live on 3347 Shadow Bluff, Las Vegas, Nevada. Been a resident for approximately 52 years in the state of Nevada. I've been hunting and fishing for a long, long time. I actually just doing fishing. I actually had 4 years at Dallas Air Force Base with honorable discharge. I with Intel for 25 years. I was with CCSD, Central Clark County School District, for 24 years. So I've represented the state pretty much. I got involved with a gentleman with a vehicle. I took him with my, just bought a truck. I just retired, by the way, July 29th. And I bought this pickup and camper, and I don't know this gentleman that well, and he wanted me to go hunting with him. And that's what I did. I just plead, all I have left now is my fishing license, and if I could get that back, I would definitely appreciate it. That's all I want. I don't believe I'm going to be hunting anymore. I know I'm not going to be, but I have somebody that I have to represent me, and you wouldn't mind him speak on your behalf. Would that be okay? Carl Frese.
Thank you for allowing me to speak on his behalf. I should point out that I know one of the commissioners very well, Bill Young. My name is Carl Frese. I'm a retired deputy chief with the Las Vegas Metropolitan Police Department. I've known Jack Hunter for close to 7 years. I've fished with him on numerous occasions in Nevada as well as Utah. I've always known him to obey all the fishing rules and laws. He always buys fishing and hunting license, as he's told me many times. Although he has not hunted in the state in over 18 years, he realizes that the hunting license that he purchases every year goes to preserve the sport and the habitats. He made a big mistake by accompanying a man on the back of an ATV on a hunting trip that he was not a hunter on, but he was on the ATV. Now, when he first got back to Las Vegas and told myself and other friends what had happened, he was angry that he had gotten cited for doing nothing wrong. When we explained to him in terms that he could understand that he had committed a violation, even though it was through ignorance, he was so ashamed. I wish I could convey that to you. This man drove 280 miles to plead guilty in Eureka. He did not waste the state's time. He did not inconvenience witnesses or a courtroom. He pled guilty once he understood that he had made a mistake. The sentence of 3 years without hunting and fishing license to a younger man would not be that much, or to a man who is his age. But Jack has just retired. A lot of what he had planned on doing involves that hunting, or not hunting, but fishing license. And all I'm asking is that you consider this man that in the last 4 decades that he's been in Nevada has not had an infraction of any of these licenses. And look at the severity of the sentence and ask yourselves, is there room for leniency? That's all I ask. I would not associate myself with someone who broke the law or did not lead an ethical life. And that's why I'm proud to be here on his behalf today. Thank you.
Thank you. I'm gonna need some help here. What's our procedural order through this?
The department can now present its case. I believe Chief Onomichi is going to make that presentation.
Okay. Are you done with your part?
Yes, I am, sir.
Okay, thank you.
Thank you.
Chief Onomichi.
Good morning. For the record, Chief Game Warden Rob Onomichi. This case is simply a procedural type case. It's not an issue about an individual's character or anything like that. I had several phone conversations with Mr. Hunter. They were all very pleasant and so forth. But we're obligated under statute and regulation to do certain things. If I could refer you to Exhibit 1 in your package. It's the criminal complaint issued by Eureka County. And then Exhibit 2 is the judgment and sentence. And in Exhibit 2, you'll see a description of conviction, count 1, unlawful use of aircraft/boat/motor vehicle to hunt, a violation of NRS 503.010, a misdemeanor. So that's what Mr. Hunter was convicted of. You'll also see that he was fined $500 and then an administrative assessment of $120 and court fee of $70 and another court associated fee of $10. Then Exhibit 3 is just our tracking citation, again depicting that he was sentenced on, convicted on 4-1 of 12, and that it is indeed 12 demerit points. Exhibit 4 is NAC 501-200, which is a schedule of demerit points set by this commission. And you'll see right at the very top there, the first one, unlawfully shooting at game mammal or game bird from an aircraft, helicopter, or motor-driven vehicle, or using such a vehicle to molest, rally, stir up, or drive game mammals or game birds. And that is indeed a 12-point violation. And then moving on to Exhibit 5, that's our notification we sent certified to Mr. Hunter advising him that his privileges are being revoked pursuant to Nevada state law and regulation. Exhibit 6, in the middle of the page, these are the statutes affecting the demerit system. Middle of the page, NRS 501.1816, number 2. If a person accumulates 12 or more demerit points before completing a course of instruction pursuant to subsection 1, the department shall suspend or revoke any license, permit, or privilege issued to the person pursuant to this title. And then on number 3, we have 60 days in which to accomplish that, which we did. So it's important to note it's a shall. We don't have a choice. And then Exhibit 7 is Mr. Hunter's letter wishing to appeal his revocation. And then Mr. Hunter and I had a conversation, phone conversation. Exhibit 8 basically clarifies that conversation. that Mr. Hunter wished to postpone his appeal until we could meet here in Las Vegas, since this is where he lives and it'd be more convenient for him. We agreed to that, and he agreed to that. So with that, I'd be glad to answer any questions.
Commissioner Rain?
A couple, and I don't know, some of the stuff, maybe I'm reading too much into these complaints, but this was alleging that Mr. Hunter was the driver of this vehicle, or he was a passenger in the vehicle. How does that work under the law if you're a passenger? I mean, you know, you're driving, I know, you know, you're speeding, the passenger doesn't get a ticket. How does it work in the game department?
Not to associate Mr. Hunter at all with this severity of a crime, but it's like a bank robbery. If you're in the vehicle, you're principal to the crime. You're subject to the same penalties and laws as the person that went in and actually robbed the bank.
And
so it's a principle. It's in Nevada statute. He was also charged with that. NRS 195.020, that's the principal statute, where he acted as a principal.
and perhaps to clarify my mind, because I'm not that familiar with that section of law, where is the dividing line between, you know, passenger in the vehicle doesn't get the speeding ticket, driver does, and this type, and this where you're on, where you're equally guilty? I understand that there are many instances like the bank robbery, of course, but where is that dividing line?
The dividing line is the district attorney makes those calls, and if they feel that it was an active participant as far as the activity, this is different than speeding down the highway, because the passenger has really no control over how fast the driver is going. Doesn't have access to the brake pedal, doesn't have, you know, he's just driving down the road, may be asleep, may not even be aware of it, but certainly in this case, you know, it was obvious that Mr. Hunter was aware that, you know, this activity was going on.
I'm just trying
to felt that.
Okay, I'm just trying to clarify that, and that actually makes some sense. So, therefore, not just a, this certifies it was not just a inactive, just sitting there, observed it. This is actually stating that he was indeed an active participant up to the degree that the driver was. And I'm correct in, is that correct?
Yeah, Mr. Hunter may have a different version, but
okay,
that's
I mean, it's the state's case. This is what this document is alleging. And at this, and just a question, you've stated many times that there's a lot of leeway perhaps in what a game warden will cite someone for, depending on conditions. And this condition, the game warden in this station, in this, what would have, you're a game warden, you drive up on an instance, what are your options in citing him? You don't have to cite him with the maximum for everything. What are the options that he had at that time?
We have options. Also, this came through, there were hunters that reported this to us. So it was not at firsthand observed by a game warden. So there was an investigation that ensued, statements from hunters and all that. And the DA was turned over to district attorney's office, and the district attorney in Eureka County felt that there was ample cause to charge and obviously convict.
Okay, so but just to clarify that, at that point in time, once that investigation was done by the game warden in question here, then he went out, and at that point in time, he made a determination that both of what citations he could have, in his judgment, that was the thing at the time. No.
No, in this case, it was turned over to the district attorney's office.
Is this turn made that?
Correct.
Okay, because that's, you know, I'm
yes.
trying to figure out the chain of who did what and who made, it's not exactly obvious
the officer investigated the report of criminal activity, turned those reports over to the district attorney's office and the facts at hand, and the district attorney made the decision whether to proceed with prosecution or not.
So the initial citation was not done by the game warden, it was done by the district attorney's office?
Correct.
Okay.
That's what you see on Exhibit 1.
As I was
criminal
trying to
complaint.
find, usually there's a little ticket there that shows, you know, you got cited by the game warden and at that time. And that's, I saw there was one, but that was...
Yeah, you will also notice on Exhibit 3, in the the citation, at the bottom, towards the bottom, it says criminal complaint. So the officer didn't issue a citation in this case on the scene. And in fact, I believe the individuals had left the area by the time we arrived.
That clarifies it in my mind. Thank you.
Commissioner Macbeth?
We've been down this road before, and you know, our duty as the commission is not to you know, determine what you know, happened in the initial you know, whatever happened in court. The bottom line for us is that there was a plea, and all we're doing is reviewing this, and correct me if I'm wrong, is reviewing this for procedure to make sure that the department followed the proper procedure. And if we make that determination, then that's the end of it. And so our ability to show leniency or to somehow change what has happened under the statute and regulations, we simply do not have that authority. I just want to, we've done this before, and so I just want to make sure that we're all on the same page, and maybe for purposes of explaining to Mr. Hunter Watt, you know, what's going to happen here. Our hands are tied in this to a great extent that we simply have no ability to do much here other than to review it for procedure. Is that correct?
In full disclosure, that's what we've been told in the past by the Attorney General's office. However, our DAG at hand has stated that the commission, it's silent to that issue, so the commission in theory could reverse decisions. But I would argue against that from the standpoint of we're enforcing the regulations set forth by this commission, and then under NRS 501.181, under 1C, the commission shall establish broad policies for C, the promotion of uniformity of laws relating to policy matters. So I would argue that for uniformity's sake, this is how we've always handled these situations in the past, and that it's predicated under sound established regulation and current law with notification periods and so forth. So there's a myriad of procedures in place that we are obligated to follow, and we have done exactly that.
The second thing I want to mention is that, and I've said this before, and being an attorney, you know, I feel, you know, for these situations, but the critical time to work out the deal, both for the criminal side and the civil side, is in the criminal court. And by pleading, you tie our hands. Not only do you plead to the charge, but you tie our hands to do anything. And so the place would have been at the, instead of going in and pleading guilty, just, you know, and that's admirable, it really is. But, you know, I think, you know, that I could see a DA, you know, looking at extenuating circumstances where you were on the, you know, you were just there, and maybe agreeing to, you know, a plea deal where it would have been a lesser charge and therefore under 12 demerit points, and therefore we wouldn't even be here. And so I say it again, every time one of these cases come before the commission that I've been on, I've said this, is that now is not the time to be asking for leniency. The time is to look ahead. And unfortunately, I don't think that the DAs really get into this civil side and how what is going to happen in that court is going to impact your future ability to get a hunting or fishing license. And I think that's the part that maybe, I don't know if there's anything to be done, but anyway. But you know, we all, I'm sure that everybody on this commission is feeling, you know, the way I am, that, you know, I feel that there's, you know, there could potentially be extenuating circumstances, but nobody ever got the opportunity to do anything about it, and, you know, because of the plea deal, and that was the end of it. So, anyway, I guess that's it.
Any other commissioners have anything? No?
Chairman Robb, according to the procedure that we have, Mr. Hunter has a right to question the department.
Okay. Mr. Hunter? We're not in a formal, can he do that? There was a question, and we're not in a formal court of law. I don't know if he needs to be an attorney to represent him.
I'm not an attorney, I'm just his advocate. The only things I'd like to point out was that when Mr. Hunter went to court, there was not a representative of Fish and Game at that hearing. There was not an attorney for him. There were no witnesses against him. Also, I don't know if the report clarifies, but Jack Hunter was not armed on that four-wheeler. He was not hunting. He's already stated that he understands that what he did was wrong at a later date. All I'm asking you to do is consider, was procedure followed there in that courtroom in Eureka when an agent of the state was not there? A witness against him was not there. There was a pleading and a chance for an arraignment, which is not clear. As you know, my friend is elderly. He did not have representation. I think he made a mistake by pleading at that point. But I feel guilty because it was myself and another friend who convinced him that what he had done on that ATV, knowingly or unknowingly, was wrong. And that's why he drove 280 miles to say, I'm sorry, I did this. So I'm asking you, was procedure followed? No game control agent cited him at that scene. The witness and the evidence, basically, when he arrived in that courtroom, was hearsay because they were not there. One of the basic precepts of law. And yet he still took responsibility erroneously. He should have said not guilty. It would have been dismissed. All I'm asking you to do is look at the powers that you do have. And if you want to revoke his hunting license forever, I think that's in your position, and he doesn't care. But fishing is one of the few things he has left that he enjoys in his life. And I think there's room, if we look at the evidence, to say that procedures weren't followed correctly. That he would not even have been cited if he wouldn't have talked to a deputy on the roadside he was already in Ely when they were stopped and talked to. If he wouldn't have been honest with the officer, it would have been a stop and release. We don't have a criminal in front of us. We have a man that made a mistake, but I think we have an agency that also made mistakes. They should have been there in that courtroom when he arrived on April 4th. They weren't. I think the record will clearly show that in the Eureka courtroom records. Thank you.
And I understand that line of thinking, but pretty much everybody up on this commission knows I've been to court several times for speeding tickets, and every time I go to a preliminary hearing like that, there is nobody representing the higher patrol there. I plead not guilty, and then I get another hearing date, and then that's when the agency shows up for the second hearing. So I don't think we missed anything procedurally there. So that's my viewpoint on that part.
Chairman Robb, the department can also question Mr. Hunter. So does Chief Onomichi have any questions?
Do you have any questions? Okay, no questions.
So now we go to closing arguments.
Closing arguments. Is there anything else anybody'd like to say? Chief Onomichi.
For the record, Rob Onomichi, Chief Game Warden. Again, as I stated earlier, this isn't have anything to do with Mr. Hunter's character or anything like that. It's simply we're following the laws set forth by the legislature and this commission. And as far as our not doing our due diligence by not showing up for a plea arraignment, plea agreements are struck all the time without officers being present in the courtroom. It's when you go to trial and so forth, you have a right to be faced by your accuser. So, with that, thank you.
Okay.
Does Mr. Hunter have a closing argument he'd like to make?
Okay, so I'll bring it back to the commission.
All right, the hearing is now closed and the commission can deliberate.
Okay. Commissioner McNich.
Thank you, Mr. Chairman. I guess I had a question for our DAG. In reference to the statutes or the codes not speaking to, what was that in reference to? What exactly does the statute or the regulation not speak to?
I don't understand your question.
A minute ago, somebody made a comment that we'd been advised that part of the regulation or part of the statutory language did not speak to it. What do we have the authority to do? I mean, we're evaluating procedure here because it almost sounded like there was an implication that we can reverse a court decision, which we can't do.
No, the judgment conviction is the
Stands.
judgment of conviction.
Right.
What Mr. Hunter is here to do is ask you to, under 501-1816, the department is required to send out notices whenever there are demerit points. And those requirements have all been met, and I believe that's what the department was implying or referring to when Chief Onomichi said that the process has been followed, and that process has been followed. However, also under 501-1816, Mr. Hunter has a right to come before the commission and plead his case, and the commission does have the authority to consider his request.
Okay, so because I know you've heard me ask this many times. I've been through a couple of these, and the statutory language says, it doesn't say may, it says shall. The department shall suspend. I mean, so we can't reverse statutory language either. To me, it just, that's what, I guess I've always asked this question. I've said it, you know, that we're required to provide some kind of a due process on procedure when ultimately the statutory language is clear. If somebody has 12 demerits, the department notifies them of such in the appropriate time frames, and then those points are, and then that license is suspended 30 days afterwards. That's it. Because it says shall. Under number 3,